Well, Petrochemicals group Sasol has rejected allegations that it broke competition law and plans to contest charges that it overcharged its customers. Yesterday, the Competition Commission proposed fining the group 10% of the turnover of its chemical industries division for charging too much for propylene and polypropylene. Well, with more on that, I'm joined on the line now by Oupa Bodibe. He's Manager of Advocacy and Stakeholder Relations at the Competition Commission. Oupa, good afternoon.
Good afternoon. How are you?
Good, thank you. Oupa, it seems a little bit blurry. Sasol says its pricing has been comparable to international prices, and it says there's no basis for the allegations. This is now obviously going to the Tribunal. Sasol wants an amicable resolution. Are you prepared to talk?
Well, if they put something reasonable and that we think resolves the competition problem, we are open to discussion. But let me state what our contention is that in terms of our local customers, they pay 32% higher than export price. So that means that local customers are paying for these products as if they were imported when they are produced local. So that's the basis of our contention.
Now, the fact that Safripol has agreed to pay a penalty of 16.5 million rand would imply foul play on both companies' parts. It's admitted to collusion. This is a 3-year-long investigation, of course, that's been going on by the Competition Commission. Are you confident you're going to win it?
Well, we think we have a very strong case, and given the fact that we've now settled with Safripol, that put us in an even more stronger position to take this case forward.
Well, of course, Oupa, this is just the latest in a long string of cases that have been uncovered and investigated by the Competition Commission, many of those to do with Sasol, unfortunately, but also covering a whole range of other industries. Is the Commission finally rooting out foul play in South African industry?
We are discovering that anti-competitive behavior is very endemic in this economy. And we are helped by the fact that we've adopted a proactive approach to investigations, but also our corporate leniency policy has been a very successful policy, which allows firms to come forward and to get in return for conditional leniency. So that's the problem that we found facing in the economy.
Just with that corporate leniency, do you think that's really the key to the success of the Competition Commission over the past few years?
Can you repeat that again?
Do you think this corporate leniency is the key to your success over the past few years at the Competition Commission? Yes,
certainly, as well as the Commission adopting a proactive approach to investigations rather than a reactive approach.
Now, you've said that this anti-competitive behaviour is endemic in South Africa. Why is it endemic? How did it get to this state?
I think part of the problem is the practice in the past, before the Competition Act itself was changed. There was a very close collaboration, industry networks and social networks embedded in the South African way of doing business. And I think we're dealing with that history, that legacy of the past.
Just looking perhaps at SABMiller, there's a case against it by distributors. That's at the Competition Tribunal this week. And this case was referred by the Commission. There were reports on Wednesday that you approached the company for a settlement, and this was on the very first morning of hearings. Does that mean you're not confident of winning this case?
Well, we issued a statement yesterday first to clarify that we didn't approach SAB as reported in the media. We were approached by the legal representatives of some of the distributors that are appointed by SAB for possible settlement talks, and we listened to them. Unfortunately, they were not putting something that is convincing to us, and that's why the case is continuing.
So is this case then likely to run its course at the Tribunal?
That is very difficult to say. I mean, anything can happen. You may find that the parties may decide that they want to settle and we can have very fruitful negotiations, or else it can just drag on until the Tribunal makes its finding on the matter.
We have to leave it there. Thank you very much for your time this afternoon.